I still have my citation from last time. I'm still going.
I don't care about citation from last time. Get out of the vehicle.
It
You're
just-
under arrest. Plus the fucking window. I don't give a shit.
Alright guys, buckle up. Today we're diving into one of the most bizarre courtroom showdowns you'll ever see. A so-called sovereign citizen walks into court thinking laws don't apply to her, and the judge isn't having it. From the very first moment, the tension builds. She's challenging authority, and you can almost feel the judge's patience wearing thin. This intro sets the stage for chaos about to unfold in full force.
Okay, we had just called 25 CR 250, State of Kansas versus Sidney Taylor Leslie, Jared Regier for the state. Miss Leslie appears in person and per se. Miss Leslie, is that you?
Yes, Your Honor.
Where's your attorney? Are you going to have an attorney represent you?
I am presenting myself.
You know you have the right to an attorney, to hire any attorney of your choice. If you cannot afford to hire an attorney, you can apply, which I think you've already done, but you did not request an attorney, is that right?
I did not request an attorney. That is correct.
You want to proceed on your own behalf, and you can do that. No one's going to stop you from doing that. But is anyone making you give up your right to an attorney today by any threats or promises?
No.
You understand you can hire, and if you can't afford, you can apply for court appointed. And if you qualify, one would be appointed. Do you understand that?
I comprehend, yes.
You do not wish to have an attorney.
I do not wish to have an attorney.
All right, I will show on the record that you've waived your right to an attorney and that you're going to proceed on your own behalf. So how do you plead then, Miss Taylor, or Miss Leslie, I guess it is. I'm sorry, I'm just saying it wrong. Miss Leslie, how do you plead to count one, interference with law enforcement officer?
A plead would be inappropriate at this time. I'm hoping to request a continuance.
Why would a plea be inappropriate at this time?
Okay, so Your Honor, for the record, I am Sidney Taylor Leslie in propria persona sui juris. I am here by special appearance only and not making a general appearance. I reserve all of my rights, remedies, and objections, including but not limited to any objection to jurisdiction over my person. I require a continuance in this matter. I intend on filing a subpoena for body cam and cruiser footage. There are facts in dispute on this matter that I'm looking to clear up before the matter can continue further.
The hearing heats up fast. The defendant insists she's traveling, not driving, as if the right word could raise a traffic violation. The judge tries reasoning, but she keeps doubling down with bizarre legal jargon. The atmosphere gets awkward. Courtroom officers shift uncomfortably as the judge's frustration starts to surface. You can see where this is going, and it's not ending well for the so-called sovereign traveler.
All right, I will grant a continuance for you to obtain discovery, but if you don't know how to do the things you just rattled off, you better have an attorney do it for you. Do you understand?
I understand.
All right. Mr. Aguirre, do you wish to be heard before I pick the date for this?
Your Honor, this does appear to be the first setting since the first appearance hearing before Judge Hart back in June. If the court is prepared to set this matter over for discovery purposes, the state does not object. I'm not sure if the court wishes to set that matter for merely control at this time, but I'll defer to the court on that point if the court will find that the bond is being continued and this continuance is at the request of the defense for speedy trial purposes.
All right, Miss Leslie, you're charged again with interference with law enforcement officers, a Class A non-person misdemeanor, driving without insurance, a Class B misdemeanor, and driving without a license in your possession, an unclassified misdemeanor, as well as failing to register your vehicle, another unclassified misdemeanor. The judge would have gone over these with you at first appearance. You want to go over them again as far as the penalties?
No, thank you.
All right. And you've indicated you want to exercise certain rights that you are entitled to and encouraged to. But as I said, an attorney could certainly help you carry out those rights. And you said you do not want that attorney?
That is correct.
Okay. Well, I'll have the record and the docket notes show that you have waived your right to counsel and that you know what you're doing. Now, then, do you want to set it for trial, Miss Leslie, or do you want to get the records and look at them and then set it for trial?
I would like to have a continuance.
Things explode when the judge finally loses patience. After multiple interruptions, he raises his voice, cutting her off mid-sentence. This is a moment every viewer's been waiting for. The calm authority turns into controlled fury. The courtroom falls silent. The sovereign citizen's smirk fades as reality hits her. The judge's tone says it all. You're not above the law, not in this courtroom. Pure cinematic justice.
Or an evidentiary hearing if possible.
Well, I can continue it for both those readings.
Okay.
For both those readings, to give you time to get all your discovery, the dash cam, body cam things you were mentioning.
Okay.
And then we can also set it for trial. So when's a good 1:30 trial date, Jim?
Your next one will be September 24th.
All right, you'll need to be back here with all your witnesses September 24th, 2025 at 1:30, and that will be by Zoom again.
Your Honor, if I may just get a little more time due to the fact that I'm going to be submitting the subpoena and I'll need discovery and I need to just review it so that I can have adequate time to present myself for my defense.
Well, that's 30 days. You don't think that'll be enough? How much time are you asking for?
I'm hoping for at least 60 days.
Jen, do we have 60 days?
We have October 22nd or October 29th at 1:30.
Which of those do you prefer?
I would prefer October 29th.
October 29th. This is continued to October 29th at the defendant's request. Is that over your objection or not, Mr. Ricky? I don't remember any objections.
Your Honor, if the court is prepared to set this matter for trial, the state does not oppose that, but the state will be requesting a ruling as to whether or not the bond is to be continued and if this continuance is at the request of the defense.
Court does find this request at the defendant's, and the time will count against the defendant for speedy trial purposes. The matter is continued for bench trial to be heard and to be commenced August 22nd, 2029 at 1:30 p.m. via Zoom. So Miss Leslie, it's going to be here by Zoom. Right? Be sure you have your evidence ready. If you're going to screen share it, whatever you're going to do, make sure you can do that. And if you need any help getting your discovery or presenting your evidence.
Next up, another defendant. Same delusion. This time, a man who swears he doesn't recognize the court's jurisdiction. He talks circles around himself, quoting fake laws and imaginary rights. The judge stays professional but visibly annoyed. Each time the man speaks, he digs himself deeper. What should have been a quick hearing turns into a logic-free spectacle. This is sovereign citizen logic at its finest, and most painful.
You're always able to hire an attorney, and if you can't afford one, apply, but do it well in advance of the trial so that you can get the application completed, returned, and the court can appoint your attorney, and you and the attorney can have time to present your case.
Okay, yes, Your Honor, I did hear you say October 22nd. Was it the 29th that I had requested at 1:30?
You did, so I'll make it October 29th. Jen, you said
Thank
either. You said either, and she picked the 29th, correct?
That is correct, Your Honor.
It'll be October 29th at 1:30. Now, Mr. Regier will be subpoenaing witnesses himself for the state. And if you find out or decide you don't want to go with a bench trial, let him know as soon as you can so he can cancel any of those witnesses that he may have coming in.
Thank you, Your Honor.
You're welcome. And don't forget, you can look at diversion and see if that's an option. You can call the county attorney, but definitely look into that issue of an attorney.
Okay, thank you, Your Honor.
You're welcome. Anything further from the state, Mr. Regier?
Your Honor, if the court is continuing the bond in this matter, I have nothing further at this time.
I am continuing the bond, all existing conditions plus the new ones I've stated on the record today.
Thank you, Your
And
Honor.
you're welcome, and Miss Leslie is excused at this time.
Thank you, Your Honor.
And we have defendant Jose Elizondo. Yes.
Mr. Elizondo, you have a motion that was filed, so we will get to that after I take everyone's announcements. I just want to let you know that I do have you here, and I see that you're here, but I'm gonna take the announcements first, then we'll get that heard. All right, so if you can just stay logged in, we'll get you processed through promptly, all right?
As this man continues, the courtroom's patience runs out. The judge calmly dismantles every argument he throws out. When the defendant realizes he's out of tricks, he tries to play the victim card, claiming he's being oppressed. The judge doesn't flinch. You can practically feel the walls closing in on the defendant as the power dynamic shifts completely. He walked in confident, but now is cornered and speechless.
Okay, thank you. All right, Mr. Bishop, we have two defendants with motions, and then we have one defendant set for trial. All right. So the first case set for motion is Jose Elizondo. Mr. Elizondo, if you can please unmute and show your video.
I'm here.
Okay, thank you. So, Mr. Elizondo, you had a pretrial hearing earlier this year in May, and then at that hearing, you had indicated that you had mailed in a motion for a bond, and that was the only motion that you had, and we did not have that here. After the court, and we set your case for a jury trial on August 28th. Then after the date of your pretrial hearing, we received a motion in the mail stating defendant's Rule 91 motion to dismiss for failure to state a claim upon which relief can be granted. Mr. Bishop, have you received a copy of that motion?
Your Honor, and made a response.
Thank you.
I believe he's filed two motions. I've got a motion to dismiss and then a motion, no consent given motion.
Yes, that's correct. All right. So, Mr. Elizondo, if you wish to summarize your argument, you may do so at this time.
Yeah, I just want to know, do y'all enforce the Texas Transportation Code?
No, sir, we're not answering questions. You need to summarize your motion at this time.
All right, well, I just want to add to my motion that according to the Texas Transportation Code.
Then comes the next shocking twist. Another case, another sovereign citizen. This one tries to talk his way out of a serious charge, thinking he's smarter than the system. But the judge's experience shines through. Every attempt to twist words or deny jurisdiction gets calmly shut down. The contrast is almost poetic. Law versus delusion. Reason versus rebellion. You can't help but watch this train wreck unfold in real time.
Section 502.003 clearly states it prohibits political subdivisions from requiring registration, and my violation was due to registration. So that's all I wanted to add, and I plead not guilty and for dismissal too.
Mr. Bishop, your response?
Yes, I addressed this in my response, Your Honor. The city of Dalworthington Gardens is the political subdivision of the state of Texas. And this registration requirement is not a violation of a city ordinance. There is no city ordinance that requires individuals to register their vehicles. That's state law. And so the defendant is incorrect in applying that statute because it's a state law violation, not a city ordinance violation.
The court has read the defendant's motion to dismiss, and I have read the state's response to that. And the court is denying the defendant's motion to dismiss. I don't see where you prepared an order for me to sign. Let me see.
I did not prepare one, Your Honor, but I will be glad to prepare one.
Okay, if you can prepare one, Mr. Bishop, I will get that signed. I'm writing a notation here. Motion denied. Right. And then we have the second motion, defendants, no consent given. Mr. Elizondo, you may summarize your argument at this time.
Whatever I submitted is what I plead to continue with.
Mr. Bishop, would you summarize the state's response?
Yes, the state's response is in the state of Texas.
By now, the judge has heard it all: fake legal theories, imaginary laws, and complete disregard for authority. This final courtroom clash is intense. The defendant starts off smug but quickly realizes the judge isn't intimidated. Voices rise, arguments collapse, and the truth lands hard. You see the instant his confidence breaks. The moment the judge asserts control, it's game over for this self-proclaimed free man.
Driving is a privilege, not a right. And by exercising his privilege to drive on a Texas highway or street, he is subject to all rules of the road, statutes, and rules. And so the state does not need his consent for him to be subjected to jurisdiction when he has violated a state law. He's not being denied his rights. Driving is a privilege, and by driving, he subjects himself to the rules of the road and other state laws regarding driving.
All right. Based upon the court has reviewed the written motion and response, motion by the defense, response by the state, has considered the arguments made here in court, and the court is denying the defense statement of no consent given to jurisdiction. Okay, so Mr. Elizondo, your case is set for jury trial on Thursday, August 28th at 8:30 in the morning. That is when you need to be here. You have cited in some of your motions civil rules of procedure. As I have warned you before, I'm warning you again, the Texas rules of criminal procedure apply in this case. This is a criminal charge, and you need to follow the Texas rules of criminal procedure. You will be expected to follow proper courtroom decorum, and as you are representing yourself, you will be held to the same standard as if you were an attorney. You will need to be here at 8:30 in the morning. You will receive information regarding the venirmen, the potential jurors, and
the final moments wrap up everything perfectly. The judges in all these cases showed unmatched patience before setting the record straight. No one is above the law. Each sovereign citizen walked in thinking they could outsmart the system and walked out proven wrong. This series of courtroom lessons is a reminder of what real justice looks like. If you enjoyed this breakdown, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.